I want to go to our guest. He is the founder of legalinsurrection.com. If you want to know where I was during the trial and keeping up and looking for a blog that's going to have respected opinions being blogged by other attorneys, as well as bringing updates and perspective to it, I was at legalinsurrection.com. And I've gone there over the last year and certainly during the election. And so a big thank you to Professor William A. Jacobson, Associate Clinical Professor of Law and Director of the Securities Law Clinic at Cornell Law School. Professor, welcome.
Great to be here.
Wanted to begin with what you had to say, and it was short and sweet, but you basically said that everything's been said, but despite the heated demands of powerful societal forces and the state, 6 women just said no, and thereby did justice. Tell me, Professor, if you were teaching this event, this trial, an event of history, to a law class, what would you focus in on?
Well, there's a lot of things I think to focus here. One is obviously the underlying law involved, law of self-defense, as well as Florida has a statute which people refer to as the Stand Your Ground statute. So there's a legal backdrop, and what people need to understand is as much press as Stand Your Ground has received and as much fury as it's received, it really played very little role here when it came to it, because what the Stand Your Ground law did, it did 2 things. One, it entitled a defendant to a pre-trial hearing at which a judge would have to make certain findings or the case would be thrown out. George Zimmerman waived the right to that hearing. The second thing that it did was substantively, it takes the so-called castle doctrine, where if you're in most states, not all of them, but in most states, if you are in your home, you don't have the traditional common law duty to retreat if possible. So if someone's attacking you in your home, you don't need to run out of your home. And what it did is it took that non-retreat doctrine and it moved it outside the home. And it said that even if you're attacked on the street, outside your home or anywhere, you don't have to retreat under certain circumstances. That never played a role in the case because the prosecution never claimed or tried to claim that George Zimmerman had a duty to retreat from the confrontation. In fact, all the evidence was that he was on the ground being beaten when the shooting took place. So what people need to understand is this was a traditional common law self-defense defense. And under common law principles, essentially principles developed over many decades and centuries in the judicial system, you are entitled to use deadly force to defend yourself if you are faced with a reasonable perception of imminent death or serious bodily harm. I think in Florida it's called great bodily harm. So that's what George Zimmerman's defense was. So legally, that's what people need to know. And what doesn't really matter is what so much of the talk was about, which is, did he get out of his car against instructions, which is not true? Did he follow Trayvon Martin? Actually, none of that matters. All that really mattered legally is at the point of the shooting, what was going on? And was it reasonable for him to expect that he had to use deadly force to prevent death or great bodily harm to himself? And that's what the legal issue is, and that's what I would focus people on.
Should the prosecution ever gone forward with the evidence that they had?
I don't think so. Obviously, prosecutors have a great deal of discretion, but at the time they filed these charges, it was a very peculiar scenario. Normally, a special prosecutor is appointed where there's some sort of conflict in the prosecutor's office that would disqualify it. So, for example, the attorney general should not be investigating himself, so you would get a special prosecutor appointed. In this case, the special prosecutor was appointed because the regular line prosecutors, the attorneys in the state attorney's office who would normally prosecute this, refused to bring charges. They did not think they had enough evidence to prove beyond a reasonable doubt even manslaughter. They refused to bring it. Trayvon Martin's family retained a law firm That law firm engaged publicity people, and then they turned this into a whole sort of racial issue, which it never was. And the public pressure, the threat of protest, the threat of violence, etc., led the Florida governor to appoint a special prosecutor. So you had a special prosecutor appointed under somewhat suspicious circumstances. Now, I'm not, saying there's no way a special prosecutor should have been appointed, but the background to it was a little unusual. Then what the special prosecutor did had all this evidence, all the evidence we now know about how the overwhelming reasonable doubt there was as to Zimmerman's guilt. They knew back in March and early April when they filed the charges, but they didn't really disclose those. And I don't think anybody objectively looking at the information the prosecutors had back in March of 2012 would say that they had a reasonable belief they could prove their case beyond a reasonable doubt. And they shouldn't have brought the charges if they didn't think they could do that. And the way the trial went down, once the evidence was released, the documents months later, everybody started saying, well, wait a second here. When you filed your criminal charges and affidavit in support of the criminal charges, you didn't mention all this exculpatory information about George Zimmerman. You didn't mention his injuries. You didn't mention that other witnesses had verified to you that he was on the bottom of this fight getting beat up mixed martial arts style. You didn't disclose any of this information to the court at the time you submitted the affidavit in support of a finding of probable cause, which is what they had to do to move forward. So a judge made a ruling on an affidavit of probable cause, which didn't even reveal all of the important information. And so I don't see how they, in good faith, could have claimed that they thought they could prove this beyond a reasonable doubt. Go ahead.
No, but is there a consequence for that omission for the prosecutor?
I don't know. I don't think that there will be. I believe individually they have more likelihood immunity. I haven't looked at that issue. So no, I don't know that there will be. I know some people at least are talking about there should be some sort of, bar discipline or something like that, but I don't see that happening. So I think really it's just kind of the shame of their conduct in the public eye is really, in all likelihood, the only consequence there'll ever be.
Many have been critical of the judge's performance. Were you disturbed by anything in the conduct of the judge?
I wasn't as critical of her as a lot of people have been. I think the biggest mistake she made was forcing this to trial before it really was ready for trial. And the defense, or the prosecution, I should say, unloaded a fair amount of new information on the defense just a month or two before trial. And so what you had is things taking place during the trial that normally don't take place during a trial. For example, taking depositions of witnesses. Those are all things that are normally done weeks, if not months, in advance of a trial. And the defense had argued to the judge, a number of months ago that they needed more time, that the case would not be ready for trial by its scheduled start date at the end of June, and that ended up being true. And so what you had is you had a lot of rulings at the trial which were meant to keep the case on track, but I think worked to the defense's disadvantage. I remember at one point, I think it was, July 4th weekend, the defense had other things to do. They had depositions to take, and they said, can we reconvene on Monday rather than Friday? And the judge said, no way, we're coming here on Friday, and we're continuing because we have a jury that's sequestered here. And there were just a number of things like that which were a result of her decision to force the case to go to trial. Substantively, she had rulings that, went both ways. She did not allow the state's audio experts to testify because really they didn't have the science behind them. On the other hand, she did not allow certain information to come into evidence showing really that Trayvon Martin was not, as he was portrayed by the prosecution, that he had some, he just days before the incident here, he was bragging to somebody via text message that, he knew how to start a fight, and the way he starts a fight is by punching somebody in the nose. And that's actually what George Zimmerman said, how this fight started. And so there were things, so I think she went rulings both ways. So I can't be as critical to her about how she handled it as some people are being.
The future, first, the perjury allegation regarding George Zimmerman's wife. Would you care to comment on that? You've commented extensively. And is there a way that will end up receiving some form of punishment that would put Mrs. Zimmerman in jail?
Well, the perjury charge is during the case, fairly early on, George Zimmerman was out on bail. Relatively low bail. I don't remember what it was. I'm thinking it was maybe $100,000 or $200,000 bond that he had to post, and that means you have to put 10% of the money up. Then they had a hearing on setting that bond amount, and at that hearing in court, Shelley Zimmerman, his wife, testified, and there were questions asked about what resources they had available and their website they had set up for fundraising. And essentially, they claimed not to have the funds for their own defense. It then turned out, I don't remember the sequence of how the prosecution found out about it, but it then turns out that they had raised $100,000 or $200,000. So they filed a perjury charge against her. My reading of it is that her answers were not that clear. The questions to her were a little vague, and a lot of what she was expressing, I think you could fairly describe as opinions as to their ability to pay, as opposed to a fact that she misstated. And
yes,
in order to prove a perjury charge, the witness under oath has to state a fact falsely. And if you just give an opinion that they
yes,
don't like, that's not perjury. And that's why the federal government...
Professor, if we could do a few minutes on the flip side of the break. If not, I realize you're... Okay, great. We're going to return.
Absolutely.
We'll get the rest of that answer. Thank you so much. We will return with Professor William A. Jacobson. He is the founder of legalinsurrection.com. More truth on the flip side. AFR Talk. Welcome back. Thank you, Todd Starnes. Crane Durham's Nothing But Truth. AFR Talk, coverage of the Zimmerman verdict with William A. Jacobson, Professor William A. Jacobson at Cornell Law School. He is also the founder of legalinsurrection.com, an amazing resource for, I will just have to speak for me, but I think a lot of us in talk radio land, and that would be legalinsurrection.com. And Professor, before the break, we were talking about Shelley Zimmerman and her testimony on the stand regarding the resources they had in the establishment of setting the bail. And there are charges, I guess, of perjury that you were commenting on the substance of those charges and the veracity of those charges. Go ahead, sir.
Right. So the issue is, did she make a statement of fact as opposed to an opinion, or was she just evasive? Because if she's merely evasive, that's not anything. If she misstates a fact, that's perjury. And that's why the federal government, your readers may see often, they'll often choose to bring obstruction of justice charges against people because of testimony, not perjury charges. And that's because perjury is really hard to prove. You have to have a very specific question about a fact and a very specific answer about a fact. And my reading of the transcript of her testimony indicates that virtually everything, or really everything, that they're complaining about might have been evasive, but it wasn't actually a clear misstatement of a fact. And that's why I think they're going to have problems. But that case is scheduled to go to trial in late August. I don't know if there's going to be any change in that, but they had postponed it until after this trial.
Professor, when we look at now a case against NBC for allegedly editing a tape, I say allegedly, but we heard the edited tape, does the Zimmerman camp have a case against NBC? And further, as I asked you earlier, does it have a case against the prosecution for the leaving out of evidence and when filing the affidavit to pursue this case?
Right. In terms of NBC, and I don't want to go beyond my area of knowledge, it would be a defamation sort of claim, or it might be a claim for what they call portraying somebody in a false light. I'm just not that familiar with the likely strength of it. Clearly, defamation claims against public figures are very, very difficult to win and to even get to a trial. So I'm just not familiar enough with what their legal theory is going to be, but there's no question that what NBC did was pretty horrible. What they did is they edited the tape of the 911 call to make it seem like George Zimmerman found Trayvon Martin suspicious because he was black. What they left out in the middle of those two pieces spliced together, the only reason that George Zimmerman mentioned that Trayvon Martin looked black is because the 911 operator asked him, is the person black, white, or Hispanic? So the way the sequence went down, he originally says nothing about the race of the person he considers suspicious. It's only when the police ask him to identify a race, and NBC cut out that whole middle part of the conversation. And it came at a very critical time where the Martin family lawyers and supporters were trying to portray this as a racial incident. And lo and behold, NBC purports to have the tape that proves it. And that really, I think, cemented in the public's mind in many ways, the fact that supposedly George Zimmerman was racist. And the way the media has portrayed it is, a white person versus a black person. But in fact, George Zimmerman is multiracial. His mother is Hispanic, I believe, from Puerto Rico. I could be wrong on that, but definitely Hispanic. She testified at the trial. And I think one of his grandparents is black. So he is a very multiracial person who's grown up in a multiracial family. But all you ever hear in the media is white versus black. And that's just factually not what happened. But NBC helped, cement that sort of misperception in the public mind. Whether there's a viable legal claim, I'd have to look at some more.
Okay, and Professor, as long as we're hitting the race issue one more time, before I go to the question of civil rights from the Department of Justice, I want to go back to what you spoke to earlier about, if you're on a panel, and I'll even say this, a number of people who've responded to the question, who I obviously share your opinion when it comes to this case, but hey, it's great people disagree, but what they're disagreeing with is they say things like, he never should have gotten out of the car. And the other part to that is, then if that doesn't, hit, we're going to just keep bringing the race into it, saying this was a racial case of racism and overreaction. If you're teaching people who are making, asking those questions and invoking those statements, tell me something, Professor, what do you say to them?
Well, you have to take every case on its own. A lot of people want to generalize, and they say, because there are still problems with how the police interact with black suspects or black victims, that makes this a case about race. But the facts here are that there's nothing to suggest that George Zimmerman was motivated by racial animus. I've mentioned how he himself is multiracial.
Sure.
The FBI actually investigated this at the Justice Department's request. Interviewed, I think it was 30 people who knew him, not just family members, but other people who just knew him, and could not find a single person who would say that he's ever expressed any sort of views or done anything that would support that. So the FBI essentially found that there's nothing there. There's nothing in the incident itself that suggests that. So this is just a concocted narrative which has dominated the case and is leading to protests, but there was never anything to it. It was just a political agenda that people used to, pursue their own, political causes. So, that my admonition to people would be: you always have to take every case on its own. You can't approach a case and say, "Aha, this is the type of case it is." What you have to do is find out about this specific incident and what the facts are here. And I don't think the prosecution ever could have proven that this was racially motivated.
And therefore, the Department of Justice, you're saying, has no case.
Well, there's two issues with the Department of Justice. I believe that the statute they operate under really normally applies to public officials. So the police, essentially. So, for example, in the Rodney King case and other cases where the police have been acquitted by a jury, sometimes, not always, but sometimes they would try to bring these civil rights charges. But those are because the police are state actors. They're acting, under the color of law, as opposed to George Zimmerman, who is just a private citizen. So there's a legal issue there that they'd have to get past. Assuming they could get past that legal issue, then the question becomes, is there actually any facts to support it? And, that, I think, would be the bigger problem. It was very obvious, even by the people who testified at the trial, that, there was nothing in his background to suggest anything like that. And so I think that if the Department of Justice were to bring a civil rights case against him, it would clearly be politically motivated. Unless they know something that never came out in the trial and never was revealed in the course of the investigation during the case that's been made public, unless there's something out there that they know that the rest of us don't know, there's no basis on the facts of this case for them to charge him with violating Trayvon Martin's civil rights. Because if they did, then they would have to bring those charges in every single murder case or every single battery case where there's an interracial component to it. And that's just not what they do.
Professor William A. Jacobson, he is legalinsurrection.com. He is the founder. He is also a professor of law at Cornell Law School. And I want to say thank you for taking the time and doing such great work. I would